Good afternoon. My name is Kay Shirey. I have been the rule development lead for this rule implementing the Climate Commitment Act. As you can see from the list on the screen, a lot of people have been involved in developing this rule in addition to myself. So the public meeting, the agenda for this part of the public meeting is, for my presentation, is I'm going to talk about the rulemaking process. I'm going to talk about the basics of the Cap and Invest program, a very high level general discussion of how it works. Then I'm going to talk about the structure of the proposed rule, the basis for the proposed rule, and then for those of you who've been following this process from the beginning, I'll talk about some of the major differences between the January draft that we put out for this rule and the May 16th, 2022 proposed rule. Once that presentation is done, we will take questions. So the rulemaking process, we started with rule development. We had a number of stakeholder meetings between November 8th and January 26th. We had an informal comment period. Now we are in the proposal phase for this rule. We put out the draft formal rule proposal on May 16th, 2022. The formal comment period runs through July 15th, 2022. This is the third of 4 public hearings we're having on this rule. We had 2 last week, and we have another one tomorrow in addition to today's public hearing. I want to say that, and we're planning to adopt the rule by the fall of 2022. The informal comment period, we heard from about 80 of you, and we really thank you for your comments. Your input was crucial. We made a number of changes to the rule language based on your comments. The basics. This is basically how the Cap and Invest program works. The first thing we do, Ecology is required to set a baseline for the greenhouse gas emissions covered by the Cap and Invest program. And then, and it's generally based on emissions between 2015 and 2019. That baseline is an annual, it's a baseline of annual emissions of greenhouse gases from the sectors that are covered by the Cap and Invest program. Ecology must also set annual allowance budgets for each year for greenhouse gas emissions from covered entities. And these annual allowance budgets must decrease annually at rates to ensure that the emissions covered by the program reach the % reductions required for 2030, 2040, and 2050 in RCW 70A 45.020. So Ecology sets the baseline, sets the cap decline rate, and issues and sets and creates annual allowance budgets for each year, and then creates sufficient number of allowances each year to cover the annual allowance budget for that year. The program covers about 75% of the greenhouse gas emissions in Washington state and does not cover about 25% of those emissions. What's not covered are agricultural operations, small businesses, aviation fuels, and most marine fuels. So what is covered are industries, large industries, electricity consumed in Washington state, gasoline and on-road diesel emissions, natural gas burned in homes and businesses in Washington state, and in 2027 we'll bring in waste to energy facilities, and in 2031 railroads. So this graph shows the cap decline rate for the various years of the program from 2023 through 2050. You can see it's very steep in the beginning because the statute RCW 70A 45 requires emissions in 2030 to be about half the emissions in 2022. So it's a very steep decline in the first 2 compliance periods, and then it gets a little less steep as in the later compliance periods. So the cap and trade program, the Cap and Invest program is basically a trading program, and the commodities that are traded in the program are compliance instruments, of which there are two types. First are the emission allowances that we've been talking about, and second are offset credits. Each of these, one allowance and one offset credit, is worth 1 metric ton of carbon dioxide equivalent. The allowances can be obtained by direct distribution from Ecology for some covered entities that are specified in RCW 70A65 in the statute. Folks can also purchase allowances at auction and can obtain allowances by trading for them with other people in the program, other entities in the program. So there are 3 ways to participate in the trading program. You've got covered entities, and those are greenhouse gas reporters in Washington that meet the covered emission thresholds. They are required to participate in the program. Then you've got opt-in entities who are greenhouse gas emitters that don't meet the covered emission thresholds but choose to participate. And when an entity opts into the program, it takes on all of the compliance obligations as if it were a covered entity. And then there are general market participants, which is anybody else who wants to hold allowances. Before any of these folks can participate in the program, they have to register in this program. And in addition to registering, they need to obtain accounts. You have to have an account in order to have allowances, and in order to get allowances through auctions or by trade. In order to get an account, you have to disclose to Ecology certain direct and indirect corporate associations of which you are a member, and designate at least 2 account representatives to act for you in the market. Once you have accounts, you can trade compliance instruments with other registered entities. You are eligible to participate in auctions. Trading is handled by each registered entity's account representatives. The trades go through Ecology, and once a trade is approved, Ecology transfers the compliance instruments from the seller's account to the buyer's account, or from the person who wants to transfer the allowances to somebody else from that account to the new owner's account. So auctions. There are several types of auctions that will be held every year by Ecology. They all have more or less the same process, with a few variations that are noted in the rule. There will be quarterly auctions, 4 auctions a year of current and prior vintage allowances. Vintage in this case means the year of the emissions that the allowances cover. So 2023 vintage allowances cover emissions for 2023. So current and prior vintage allowances, there are 4 auctions per year. Future vintage allowances, we will hold 2 auctions a year, or we're proposing to hold 2 auctions a year. And they will be in parallel with 2 of the 4 quarterly auctions of current and prior vintage allowances. Then there are emissions containment reserve auctions that happen when new covered and opt-in entities enter the program. And then there are auctions of allowances from the allowance price containment reserve. There are 3 things that trigger those kinds of auctions. One is when the auction price for one of the quarterly auctions reaches the tier 1 allowance price containment reserve price, and we abbreviate allowance price containment reserve as APCR. So when auction prices reach the tier 1 APCR price, then that triggers Ecology offering an auction of APCR allowances. Another thing that triggers an APCR auction is when new covered and opt-in entities enter the program and there are no allowances left in the emissions containment reserve. The third thing that triggers an APCR auction is we're proposing to hold 1 auction a year from the APCR that would take place between the final quarterly auction and the compliance deadline. This is to give folks a last chance to purchase allowances at auction before they and to ensure they have sufficient allowances to meet their compliance obligations. So this is not the highest bidder gets the prize auctions. This is a single round, single bid auction. The settlement price is the price of the lowest viable bid that is at or above the floor price, and everybody pays the settlement price. So bids, you can bid as many times as you like. You can bid for whatever number of allowances you want to in each bid, and you can bid at whatever price you want to for each bid. To be acceptable, bids must not violate the bidder's holding limits. They must not violate the bidder's purchase limits, and the total cost of accepted bids must be covered by a bid guarantee that has been provided to Ecology. Like I said, all bidders pay the settlement price, and all viable bids are accepted that are above the settlement price until the allowances run out. There are several measures in place to keep auction prices from bouncing around too much. There are 2 measures to keep auction prices from getting too low, and 2 to keep them from going too high. So the price floor is a mechanism to keep prices from going too low. Ecology cannot sell allowances at auction for less than the price floor or the floor price. The emissions containment reserve trigger price authorizes Ecology to withhold allowances from auction to raise the settlement price up to the emissions containment reserve trigger price. We are proposing to suspend this mechanism for now. So we are proposing the proposed rule suspends the emissions containment reserve trigger price. The two mechanisms to keep auction prices from going too high. One is the allowance price containment reserve, and Ecology holds auctions at the like I said before, of the APCR allowances when the settlement price in the previous auction reaches the tier 1 APCR price, and once a year before the compliance deadline. And then there's the price ceiling, and Ecology is required to sell price ceiling units at the ceiling price to entities who do not have sufficient compliance instruments to cover their next compliance obligation. And I will say that price ceiling units are not under the cap. So whenever Ecology issues a price ceiling unit, that is in addition to the cap. Ecology has a duty to use the money obtained from selling price ceiling units to obtain greenhouse gas emission reductions somewhere else. So basics, we talked about 2 types of compliance instruments, emissions allowances we've just talked about, and now we're going to talk about offset credits, which is the other type of compliance instrument. So offsets are basically reductions in greenhouse gas emissions that are outside the program and outside any legal requirement to reduce greenhouse gas emissions. So an offset projects generate offset credits and qualify under the CCA. An offset project must result in greenhouse gas reductions that are real, permanent, quantifiable, verifiable, and enforceable. They have to reduce emissions that are not covered in the Cap and Invest program. They have to result in emission reductions that are in addition to those that would occur without the financial incentive in the program or that would occur through some other law or regulation. And they have to provide direct environmental benefits to the state of Washington or be located in a jurisdiction with which Washington has linked. The bar graph on the right in green shows the percent of an entity's compliance obligation that can be covered by offset credits. In the first compliance period, a particular entity can use offset credits for not more than 8% of its total compliance obligation. And of that 8%, 3% must come from offset projects on tribal land. In subsequent compliance periods, those percentages are 6% total of which 2% can come from tribal land, and the rest, 4%, comes from non-tribal. Offsets Ecology is proposing to adopt 4 offset protocols. To start by adopting 4 offset protocols, the thought is that more offset protocols will be developed over time, but we wanted to start with 4 offset protocols that have been in use by the California and Quebec trading system. These protocols were developed by the California Air Resources Board, and they are the U.S. Forest Protocol, the Urban Forest Protocol, the Livestock Protocol, and the Ozone Depleting Substances Protocol. Finally, I want to talk about compliance and enforcement. By the end of each compliance period, covered entities and opt-in entities have to have provided to Ecology 1 compliance instrument for each ton of covered emissions for the compliance period. Compliance periods last 4 years. The first one starts January 1st, 2023 and ends December 31st, 2026. So compliance instruments have to get to Ecology by November 1st of the year following the end of the compliance period. So November 1st, 2027 is the compliance deadline for the first compliance period. So in addition to the 4-year compliance period requirements, there is an annual compliance obligation. Each entity must provide compliance instruments to cover 30% of its annual emissions for the prior year. The compliance deadline is November 1st of the year after the year the emissions occurred. So the first compliance deadline will be November 1st, 2024 to cover 2023 emissions. If you don't do that, then within 6 months, you have to provide 4 compliance instruments for each one not provided by November 1st. And if you don't meet that obligation of the 4-for-1 obligation 6 months after November 1st, then Ecology can start issuing penalties and compliance orders. Each day of noncompliance and each metric ton of covered emissions that is not covered by a compliance instrument constitutes a separate violation. And there are also, in addition to these provisions, Ecology can also issue penalties for violating auction rules, providing false or misleading information, failing to provide information, and various other violations of the auction process and the cap and invest statute. So from here, I want to talk about, so that's a sort of very quick overview of how the program works. I want to talk a little bit about how the rule is structured, because I know that when the rule as it sits on Ecology's rulemaking website is just one provision after another with 100 and some odd typed pages. That's the way it comes from the code revisor's office, and that's the way we have to provide it. But I will say that there is a table of contents that Ecology posted to the website a couple of weeks ago, the rulemaking website, that it lays out each provision in the rule and the proposed rule and what page it's on in the code revisor's rule document. So this is just a quick overview. The 173.446.000 have the general requirements. That includes the definitions, the applicability, the registration, those kinds of things. The 100s are the program account requirements, the disclosure of corporate associations, the designation of account representatives and account viewing agents. The 200s provide the allowance budgets and distribution of allowances. That's where you'll find the baseline, the annual allowance budgets, and the distribution of no-cost allowances. The 300s talk about auctions, how to register for an auction, what the auction process is, and the various price containment measures. The 400s are the trading provisions. There are transfers among registered entities, that would be trades of various sorts, transfers to Ecology, and then there's a list of prohibited actions. The 500s are offsets, and as you will see if you look at the rule, the provisions on offsets constitute about half of the length of the rule. This is to make sure that the offsets really do meet the requirements to be additional and permanent, real, quantifiable, verifiable, and enforceable. So the provisions include policy offset credits and registry offset credits, what those are and how they work, offset protocols, verification of offsets, and invalidation of offsets. And finally, we have the 600s, which are the compliance obligations and the enforcement provisions. I want to move on to talking a little bit about the basis for the proposed rule. What I'm wanting to get across here is that Ecology had varying levels of discretion in developing different portions of this rule. Many of the elements of the program are directly mandated by statute. And so the sectors covered by the Cap and Invest program, the sectors receiving no cost allowances, the length of compliance periods, the purchase limits at auctions, the fact that the program is required to be designed to ensure that emissions are reduced to the limits required in 2030, 2040, and 2050. So those were things over which Ecology really had no say because they're required in the statute. Some elements in the program were subject to the requirement that the program be as ready as possible to link with other greenhouse gas trading programs. So we took the design and structure and procedure for auctions to match, be consistent with the other jurisdictions with which we were likely to link, which are California and Quebec. Same with the holding limits on the holding accounts and compliance accounts, the corporate association disclosure requirements, the offset program procedural requirements are consistent with California, and the compliance instrument trading process is also consistent with those jurisdictions. Finally, there are some portions of the rule where Ecology, it's up to Ecology's discretion completely. And so those include the dates for distributing no-cost allowances, the number of no-cost allowances greater than 2% in the APCR and the ECR, the auction floor price, ceiling price, and APCR prices, the decision to suspend the ECR trigger price, and the percent of the annual compliance obligation. So those are up to Ecology's discretion completely. And now I want to go, for those of you who've been paying attention to this rule for a while, into the major differences. These are certainly not all the differences, but the major differences between the January draft that we put out to the public and the May 16th formal proposed rule. So starting with the baseline and the annual allowance budget, there are more accurate numbers in the proposed rule for the baseline and annual allowance budgets for the first compliance period. I want to say these are not the final numbers. The final numbers should not be very different from these numbers, and the final numbers will be in the final rule. But folks at Ecology are still processing the data to refine the baseline and the annual allowance budgets. So the timeline, we are now proposing to distribute no-cost allowances by October 24th of each year for the following year. So October 24th, 2023, we would distribute the no-cost allowances for 2024. The exception is distribution of 2023 allowances, which we are proposing to distribute by September 1st of 2023. The reason for the late distribution for 2023 allowances is again that Ecology is working to set up this program to make sure that we have the data we need, and we have checked it appropriately to make sure that we distribute the correct number of no-cost allowances. So this, again, these are proposals still, and you can comment on these. Another difference, we made it clear that all opt-in entities and general market participants must consent to the jurisdiction of Washington courts and administrative tribunals. And for auctions, we are proposing to adopt the California auction floor price, ceiling price, and APCR tier prices. We are proposing to suspend the ECR trigger price as authorized by legislation that passed this year. We are proposing to make unsold allowances available for auction for 2 years before putting them into the ECR to make more allowances available for auction and help keep prices from getting too high. We are proposing to front load the APCR. In the January draft, we proposed that we would take 5% of the allowances from each allowance budget each year and put them into that year, take them away from that year's annual allowance budget and put them into the APCR each year as time went on. What we're now proposing to do is to take 5% of the allowances from each annual allowance budget from 2023 through 2030 and put them into the APCR now, so that the APCR will have a high number of allowances in it to start. So they will be available for APCR auctions starting in 2023. And those allowances would not have a year associated with them. They would be vintageless allowances, so they could be used for compliance at any time. Washington has a very small greenhouse gas market, comparatively speaking, with a very steep cap decline rate for the first 2 compliance periods, and front loading the APCR will make more allowances available sooner and should help to keep allowance prices from getting too high as the program gets going. We made a couple of slight changes to the auction process to be consistent with the WCI Inc. process. We have contracted with WCI Inc. to run the auctions. And as we got involved in how they do this, we realized that some of the things that we were proposing are inconsistent with what they do, and we decided to change our process to be consistent with theirs. They're minor changes. One of the ones that probably affects bidders the most is that we had proposed to have a separate bid guarantee for auctions of current and past vintage allowances and parallel auctions of future vintage allowances. And WCI said that's we don't do it that way. And so we changed it to make one bid guarantee to cover both auctions that are going on at the same time. That's also the same way that California and Quebec do it. In trading, we added a provision to allow electric utilities who get no-cost allowances to provide those no-cost allowances at no cost to the electricity generators from whom they purchase power. This includes providing no-cost allowances to the Bonneville Power Administration, as well as other electrical generators in Washington. For offsets, we're proposing to add one additional offset protocol, the protocol for the destruction of ozone-depleting substances. And finally, we made a few tweaks to align with the legislation that passed this year. We took out the provisions related to landfills because they're going to go into a different program. We changed the cap decline rates to account for the fact that landfills won't be part of the program. We made the trigger for APCR auctions, the Tier 1 APCR price, as required by the statute that passed this year. We are ensuring that the rule authorizes Ecology to sell price ceiling units to all covered entities and opt-in entities and not just facilities. The previous statute was ambiguous on that, and B2SSB 5842 made that clear. And we added a definition for market-sensitive information to address the confidentiality provisions that were passed in 5842. So those are the major differences, certainly not all the differences, but the major differences between the January draft and May 16th proposed rule.